My name is Perry Feldstein. I'm a law graduate with a civil practice at the Legal Aid Society. I'm here to talk to you about what to do if your landlord is harassing you and what you can do to fight it. New York State defines harassment as any act or failure to act by a landlord or the landlord's agents that causes or is intended to cause a legal tenant to give up their room, apartment, or any rights related to their tenancy. Tenant harassment can be a felony or a misdemeanor. In New York City, tenant harassment is also a housing code violation, and tenants can sue their landlord in housing court if they're being harassed. Under New York law, there are two types of tenant harassment: civil and criminal harassment. Let's define the terms. Civil harassment may include using force or threats of force, cutting off utilities like heat, hot water, etc., bringing repeated baseless court cases, removing your belongings from your apartment or room, breaking or changing the locks on doors without supplying new keys, making repeated contact about giving you something of value if you agree to move, requiring or preventing you from seeking medical help, requesting an ID that would disclose your citizenship status when you have already provided current government identification. Tenant harassment is considered criminal when it includes any conduct that makes your housing uninhabitable, conduct that creates or maintains a condition which endangers your safety or health, conduct likely to interfere or disturb or which is intended to disturb your comfort, conduct intended to or that does cause physical injury to you or another person. If you are experiencing tenant harassment from your landlord, you can file a housing part or HP harassment petition in housing court. You should make sure to include complaints of any repairs or services needed in your apartment when you file the case. The clerk at your borough housing court will give you the required forms. Fully fill out the forms provided by the clerk, including the dates the harassment occurred and any relevant details. Remember to list any conditions that need repair in your apartment and public areas of the building. You may also request that the New York City Department of Housing Preservation and Development, or HPD, inspects the conditions in your building by filling out a tenant request for inspection. The judge or clerk will instruct you how to send a copy of your harassment petition to the landlord and any other parties named, including HPD. You will be assigned a date to return to court. It is important to follow the court's instructions for serving the petition very carefully. If you do not serve the other side properly, the court may dismiss your case. There is a $45 fee to file your case, but if you cannot afford the fee, you can ask the court to waive it. To prove harassment, you must show the court what the landlord has done to harass you. The landlord will also be given an opportunity to deny your allegations or explain why there was no harassment. Evidence of harassment can include records or logs that you've kept of the harassment, letters or emails from or to the landlord, records of complaints to the landlord, records of complaints to government agencies, violations placed by government agencies, pictures or videos of the harassment, and tenant and witness testimony. The more specific and detailed your evidence, the stronger your case will be. If you win your harassment case, the court will order the landlord to stop harassing you and may fine the landlord between $2,000 and $10,000 for each harassing incident. These fines are paid to the city. However, the law also allows the court to grant a minimum of $1,000 in financial compensation to the tenant. The judge might also order the building to be enrolled in the No Harassment Pilot Program, which requires the landlord to apply for special work permits before they can do substantial work in the building. If the landlord violates the court's orders, you may request that the court impose additional penalties. If you lose the case, there is no immediate penalty to you. If you think that the judge made the wrong decision, or if your landlord continues to harass you, you have the right to file another case in the future. But please be aware, if you file 3 harassment cases in a 10-year period, and you lose each case, then the landlord can seek an order preventing you from bringing future harassment cases and requiring you to pay the landlord's attorney's fees. If the harassment is based on your protected identity, then you can also file a discrimination complaint with the New York City Human Rights Commission. Protected identity categories include race, age, gender, sexual orientation, disability, and source of income, including rental subsidies. Call 311 or visit NYCHRC for more information. Being able to live peacefully, without harassment, is a right that we should all be able to enjoy. Thankfully, there are procedures in place to help you fight back and end harassment at the hands of your landlord. There are a lot of variables to consider, but we at Legal Aid are here to help. Please visit our website at legalaidnyc.org to get more information.